remember the Lerma hearing or Lerma case. No. Is Lerma down there? That's the last one. Oh, 0524. Okay. Is the monitor on? Okay. I can't see monitor. I almost feel like putting a mirror there just so I can see if it's on or not. Let me do that. Good morning, Ms. Rourke.
Good morning. How are you?
I'm doing well. I think we're waiting for everyone, and then I have it's Mr. Weaver.
Okay, perfect.
And the clerk didn't bring the jacket, so I'm just waiting on him.
Okay.
Unless we can go without it.
Good morning.
Is what? Probably. And then if you're talking with the clerk, if you can get the Beasley, that unsealing, they said they'll come in today. They can just remind them. All right, so I have this for Christian Lerma. And so the clerk failed to deliver the jacket, so we're looking for that right now. I don't know if we can proceed without it or not. But where I'm stuck is the only attorneys on my docket listed for this is Ms. Detmer, Ms. Rourke. Not that everyone else isn't entitled to be here. I just didn't know who else would be here. Are there other parties involved?
Judge, if I could speak, good morning.
Good morning.
So we had a final hearing in this case on February 3rd, and you made your ruling at the end of that hearing, there's been an issue between Mr. Weaver's client, he represents the father, and Ms. Clark's client, the mother, as far as what that final order was supposed to, provisions in it. So that's why we do not have a final order signed and why everyone's still on the case.
Okay.
So I do think that your jacket is probably important because it probably has your docket entry.
Okay.
Yeah.
I would agree, Judge.
All right. Okay. Well, we're just waiting on Tom Waters, folks.
And then Judge Nora Barrera, who's on the call, is the conservatorship worker. I just asked her to
Okay.
be
Okay.
here. Yeah.
And Judge, my client might jump on as well.
Right.
My legal assistant said she wanted the link, and so we've sent it out, and he may jump on. I don't know.
Okay. Well, that's fine.
Hello, Mr. Guerrero. Or was it
Teacher, I went in there 14 times.
And then would you have a scan note? I emailed you if there's scan notes. This one. Document is February 3rd. Okay, so I have the jacket now. Okay. All right, so before we get started, if I can ask what's the issue and dispute?
Judge, technically, this is my motion. The department had sent out a proposed order after the final. I had some changes with regard to some of the rights and duties of mom, and Mrs. Roark indicated to me by email that she was not opposed to any of those. The department has not told me that they're opposed to them, but I know Mrs. Clark has stated that she is opposed to a few of them. And so I just set a motion to file, my version of the order. And so that's what's attached to the motion. But I think I can kind of boil down, Judge. I think Ms. Clark will agree with me on what it looks like are going to be some of the issues. And Judge, I don't know if you have a copy of what the department, I didn't attach it to my motion, but of the department's original order, probably
No,
not.
I wouldn't have submitted that.
Okay, I didn't think so. So, and Mrs. Clark can probably speak to what she doesn't like, Judge, but I think it all boils down to sections 8.21 and 8.31. I had removed a few rights and duties for mom, and Mrs. Clark.
Mr. Weaver, before we go forward, we're not on the record yet. I was just trying to get a roadmap.
I'm sorry, Judge.
No, that's fine. But before we get into details, just to preserve your records, I'd rather put this on the record for y'all to preserve any error.
Okay, I can start over on all that stuff. But yeah, I think it's 8.21 and 8.31 are going to be the points of contention. Ms. Clark, if I'm missing something, please let me know.
Are we on the same page? 8.21, 8.31 are the two things in issue?
Yes, Judge, that is correct.
Okay. Ms. Roark? Okay. All right, the court will call cause number 323-110524-19. This is styled in the matter of Christian, Krysstian, Lerma. We're here on a motion to sign filed by Mr. Weaver. This court will take notice that there was a final trial on the merits on February 3rd, 2020, with the court rendered a verdict on the motion to modify, managing, and original petition to terminate. There's a dispute between the parties as to the language that should be included in the final orders for this court to sign. Particularly, the dispute is in section 8.21 and 8.31. Is that correct, Mr. Weaver?
I believe so, Judge. Having communicated with all counsel, I believe that the department and Mrs. Roark, I believe, have no objection to the order in the form that I have that's attached to my motion, but I believe Mrs. Roark does object to 8.21 and 8.31.
Okay. So I have Exhibit A in your motion, Mr. Weaver, as proposed order to sign. Is that a good working document to start with for all the parties? Then we can go from there. Is that fair?
Yes, Judge.
Okay.
But Judge, this is Robin Detmer for the department. I noticed that Mr. Weaver just misspoke, that he said that Ms. Roark objected to 8.21 and 8.31, but I think he meant Ms. Clark. So I just, since we're not there and we're doing this, I just wanted it to be clear.
Okay.
That's right, Judge. I apologize.
Okay, that's great. All right. So Anyways, so I guess if we're gonna try and find a way to do it. Ms. Detmer, do you have a problem with the language in the proposed Exhibit A?
Don't judge because this, so Your Honor had ruled that the father was named sole managing and named the mother as possessory conservator and did order some restrictions on her visitation and that we worked that out by agreement that it was going to be suspended to begin June 1st through Tarrant County Family Court Services, but she would have to provide a clean urine analysis before that started. And so that was the, and pay child support. So that was the bones of the court's ruling. And so I think I put in my order just our standard possessory conservator rights. And so that's what Brandon and Brianne have their dispute about. And I think it's because of concerns about confidentiality of Brandon, correct me if I'm wrong, as far as Mr. Guerrero, wanting to keep his address confidential and concerns about documentation that the mother might have access to that could disclose his information. Was that kind of it? So my position is it's really kind of between the dad and the mom, and we're okay with whatever's worked out.
So the way, since Exhibit A is our working document, does the department have a problem with Exhibit A as it's written?
No.
Okay. Ms. Roark, do you have a problem with Exhibit A as it's
I
written?
have no objections to the document in Exhibit A.
All right. So obviously, Mr. Weaver does not have a problem with it since he's the one that drafted it. Ms. Clark,
Correct, Judge.
yeah, what's the issue
Yeah.
that we have with Exhibit A?
All right, Judge. I think there's three primary issues. So I'll start with the first one on page 4 of Mr. Weaver's proposed order, and that is section 8.2.1. And in that section, he lists the rights of a parent at all times, and that is governed by the Family Code section 153.073. So in his proposed order, he lists only the rights and duties of that are contained in the Family Code, the first 3, and he has omitted numbers 4, 5, 6, and 7. So that is the
So,
first
Ms. Clark,
objection.
what was that code citation again?
153.073.
All right. So dealing with 8.2.1, Ms. Clark, any other issues, or is, I cut you off, so I want to let you finish your sentence regarding this section.
Yes. That section, that is objection, and a caveat that on the 8.2.1.3, which is the third right, it's the access to medical, dental, and other records of the child. Mr. Weaver did add a caveat that it's subject to the redaction of the father's address, phone number, email, and other contact information. And my objection is not for the records to be redacted, because I understand that the father does want to maintain some level of confidentiality. However, I think that there needs to be some method of communication, and I had suggested that at least leaving the email address on there as the least intrusive method of that. That if there's an issue regarding the child, mom has to have some way to contact dad, and if absolutely all of his contact information is confidential, then there is no way for that to take place.
Mr. Weaver, your thought?
I'm okay with that, Judge. I think my client's concern having phone number and address out there was an issue, but I think emails can be easily deleted. So and I agree. I think there needs to be some way to contact. So if we can limit that just to an email address provided by the mother, I think my client can agree to that.
So when we say this information being out there, you mean as a public record or among the parties?
Is that a question for me or Mr. Weaver?
Really, it's for Mr. Weaver as far as your client's confidentiality, because these are still CPS records, and it's not, nobody can go on Jim's
Right. I mean, I'm not asking, yeah, we're not asking for like a non-disclosure and expunction or anything like that. I just, to the extent that these medical professionals have my client's information, that the information can be accessed subject to a redaction by them of, my client's phone number and address.
I guess the part I'm confused about is, does your client not wish for those among us to know what's his personal information? Like, is he worried about Miss Lerma, or is he worried about the general public finding out his information?
Miss Lerma.
Okay. So here's my concern is I don't like to leave orders dangling. And that's kind of the issue is, if there is an issue with the child that there needs to be contact, in an emergency, email is not a very good emergency contact. Like, I understand not disclosing the home address if the parties are okay with it. The phone number kind of gives me pause though, because if there is an emergency, something pops up, is that a deal breaker? I mean, how critical, is there history that would indicate that a phone number is not appropriate?
Well, Judge, you might recall when this case was tried at final on February 3rd, Mrs. Lerma's visitation was wholly suspended by the Associate Judge of the 323rd. And she had no access to the child. And Judge Smith had ordered that several months prior to the final, which has been a number of months from today. And Judge, you had made your ruling that you may recall, you had stated that you did not grant my client the termination of mom's rights like we had asked for, but you did continue the suspension of the visits. But you did say you wanted a pathway forward, and that is why the parties all got together, as Mrs. Detmer mentioned, and we kind of came to an agreement on June 1st. And so,
Mr. Weaver, I do remember. So,
okay.
So if
This was an
everyone
interesting case, Judge. It was a little different. So,
right. So everyone agrees the email address is reasonable. Is that fair to say?
Yes, Judge.
Okay. All right. We'll do email address. I'll just, right now, since you're here, Ms. Lerma, you don't have to respond, but I'm just going to let you know if there's ever a modification on this possession, don't forget to ask for more contact information. But at this point, give you updates. I think everyone's on the same page that email is a reasonable form of contact to keep you apprised of the child. Okay. Anything else about 8.2.1?
So I just wanted clarification. So on 8.2.1.3, it's going to say the right to access to medical dental subject to redaction of the address and phone number, but not email. Is that right?
Yes, we're going to remove email from 8.2.1.3.
no, you're going to
Leave it in.
leave it in.
We're actually not going to mention it, right? Because I mean, it said subject to redaction of address, phone number, and email and other contact information, but we're agreeing that an email address doesn't have to be redacted in medical dental.
Right. So we're going to strike out email from this order. So it does, the
Right.
email is not subject to redaction.
Right. Right.
Am I?
No, that sounds right to me. Yes.
So Mr. Weaver, the address, phone number,
Yes.
and other contact is
Yes.
subject to redaction. Email is not.
That's right. That's right. I was thinking, I was confused by Ms. Detmer. Yeah, that's correct.
We may want to write, since other contact information is kind of duplicitous with email, we might parenthetically
Except.
write except. Okay. Yes, Ms. Deborah.
Except email. Yeah.
And then Ms. Clark, I haven't forgotten about your other issues with the rest of the 153.073. I want to handle the email stuff first.
Yes, understood.
Okay. All right. So, Mr. Weaver, your opposition to tracking the standard language in 153.073.
Right. So I'm looking at my red line version here, but I can see what I took out based on the red line. I took out to consult with a physician, dentist, or psychologist of the child. My client has sole managing, so those decisions are to be made by my client anyway. And my client has concerns that to the extent that Mrs. Lerma has the ability to consult with these professionals, that she is going to cause problems for my client, potentially raise issues, make frivolous complaints that will turn into potential CPS referrals, because we all know these folks they are mandatory reporters. I further have taken out the ability to consult with school officials concerning welfare and educational status. That's my client's purview as well. I took out to attend school activities. At this point, mom has supervised visitation, so if she has the ability to attend school activities, lunches, and things like field trips, obviously we can't guarantee that those are going to be supervised. And the school certainly doesn't want to have the responsibility, and I don't think is going to take on the responsibility of making sure that that kind of stuff is supervised. And then I've also removed the right to be designated on the child's records as a person to be notified in case of an emergency. This child has a broken arm at school. My client wants to be notified. He doesn't want mom to be notified.
Next.
That's all I have under 8.21, Judge. I believe. I think that's all that I removed under 8.21.
So Ms. Clark is 4, 5, 6, and 7.
Yes, that is the numbers that were omitted, Judge.
Okay. Ms. Roark or Ms. Detmer, no issues with this
No, Judge.
argument. Okay. All right. So this is my thought on this one. Is what we need to do is number 6 and 7. I agree, Mr. Weaver. She does not. Her access right now should be supervised. There's no way to monitor her supervision level on a school activity. And so number 6 should not be in there. She does not have the right to consent to medical. So I think it may be a danger to the child to allow the school to give the ER notification, emergency notification to the mother, because at that point the school calls her, she can't make the decisions. It may place the child in a dangerous situation. So number 7 it's appropriate to not be included. However, number 4 and 5, I want to address that separately. I do have a problem with the word consult because of this sole managing possessory conservatorship relationship that we have with the child right now. I don't think consult is appropriate because that infers that there should be a discourse between the medical professional, which the mom does not have the right to make the medical decisions, as well as the educational. But I do feel like as a parent, she is entitled to information. So if you can put in there, she's entitled to receive information. Just as the parent, she's entitled to know what's going on. She can get school records, she can get medical records. But as far as being able to consult, meaning she can't make decisions or make an informed decision or have dialogue with these decisions, I don't think that's appropriate this time. So if you can modify the language in 153073, number 4, instead of consult, it would say receive. And number 5, instead of
Is that
consult.
already in one, in the order, the 8.2.1.1? Oh, no, it's from the other conservator. Okay, versus, I just wondered if 1 and 3 that are already in the order.
Right, that's receiving it from the other conservator.
Okay,
This just gives her the independent right to get the medical records
okay.
from the doctor or from the school. And I think as a parent, I chose not to terminate.
Okay.
So I think she's entitled as a matter of right. But I think my intent was to restrict her ability to make the decisions for the child at this time until Ms. Lerma can correct her behavior. Okay. All right. So anything else under 8.2.1?
No, Judge, those were the only objections to that section.
Okay. So for 8.3.1, Ms. Roark, do you have any issue with Mr. Weaver's proposal in Exhibit A?
No, I don't, Your Honor.
Okay. Ms. Detmer, does the department have any issue with 8.31,
No,
8.3.1 as proposed by Mr. Weaver in Exhibit A?
No, Judge.
Okay. All right. Ms. Clark.
Yes, Judge, the last objection under section 8.3.1 is that this lists the rights and duties of a parent during a period of possession, and that's governed by section 153.074. And in the proposed order of Mr. Weaver, he omits the last 2, numbers 3 and 4.
All right. I can tell you off the bat, number 3, I don't think should belong in there. I think we should deviate from the standard language. Number 4, Mr. Weaver.
All right, Judge. is that the right to direct the moral and religious training of the child? Am I looking at that correctly?
Correct.
Okay. Well, Judge, yeah, the mom has no visits right now. The circumstances that the court may recall were pretty egregious in this. And so the court has continued to suspend Mrs. Lerma's visits, and we've agreed as the parties that it's up to June 1. And to the extent that Mrs. Lerma can show that she has become more of a fit parent, I think that can be changed on a motion to modify. But at this point, she's got supervised visitation, and it's going to be at the courthouse. And so I think Mr. Guerrero is the proper parent, at least at this point. And it may change, right? Who needs to be directing the moral and religious upbringing of this child. I think the facts would show that, Mrs. Lerma is somewhat deficient in those areas.
All right, so there's no stair step, it's straight up supervised visitation, correct?
Beginning June 1st, the supervised visitation will start at Family Court Services downtown. Yes, Judge.
All right. Mr. Weaver, I understand your concern. For me, this one, I think 4 belongs in there. 1, it's a fundamental right of a parent for the religious and moral upbringing of the child. I understand it seems like your argument's more like it's kind of moot, which I kind of agree with. If the visits are supervised, then how much moral religious upbringing can she do? So instead of excluding what I believe is a fundamental right of a parent, if it's a moot issue where I don't think there could be any potential harm from it, then I'd rather just leave it in. So I think it's appropriate to put it in there. Because the last thing we want is during supervised visit for mom not to be allowed to say, this is the right thing to do, this is the wrong, at least as part of the conversation with the child. I think that's just part of being a parent and providing guidance. In the big picture of things, there's no, I know there's gonna be no corporal punishment in there. I know there's gonna be no cult behavior in there. So I think we're okay just leaving it in. Okay.
Fair enough, Judge, I get it.
All right. Anything else regarding the proposed final orders in Exhibit A from Mr. Weaver?
No, Judge, those are the only objections.
Okay. Ms. Rourke, I've affirmed you like 5 times already. Ms. Detmer, same with you. Okay. Any other issues we need to take up at this time?
No, Your Honor.
No, Your Honor.
No,
All right.
I just would ask that Brandon would make those changes and circulate it back to us so we could sign it.
I can do that.
Okay. All right. Did you take notes or do you need me to recap?
I took some notes, Judge, but yeah, can you run back through it real fast for me? I know there wasn't a whole lot of it, so.
Sure. So under 8.2.1, you should track section 153.073 of the Texas Family Code, where number 4, it would track accept instead of the word consult, it should say receive. Number 5, instead of the word consult, it should say receive. Number 6 and number 7 should be omitted. Otherwise, it should track that chapter of the Family Code.
Okay.
And then for the dispute under 8.3.1 in your Exhibit A attached to your motion to sign, we are tracking section 153.074 of the Texas Family Code, except we are removing number 3. So it should have 1, 2, and 4. Okay. Ms. Clark, is that your understanding?
Yes, Judge, and I don't know if you repeated this, but in 8.2.1.3,
Right.
we're, for the redaction of the records, right, for the email. Okay.
Yes, and then the parenthetical except for email address. So has a right to redact all the personal information, but we have to exclude the email address so it doesn't create a conflict for the healthcare provider. Okay. All right. Well, thank you very much. I appreciate everyone's courtesy.
Okay. Thank you,
Judge.
Thank you, Judge.
Y'all be safe out there.
Okay.